You ever stop and think about where a country's laws actually come from? I mean, they don't just spring out of the ground, right? For Australia, that story is pretty wild. It's a tale that involves a legal idea that basically declared an entire continent empty, a massive copy-paste of rules from the other side of the planet, and then a 200-year struggle to make it all, well, work. So let's get into it.
Right, so it all really kicks off with this one simple question. If you're founding a new colony thousands and thousands of miles from home, what do you do about the law? Do you just start over from scratch, make things up as you go, or do you pack your entire legal system in your suitcase and bring it with you? That was the exact puzzle the British were facing in the late 1700s. When the first fleet dropped anchor in 1788, the biggest challenge wasn't just figuring out how to survive. It was a legal one. See, in the eyes of the British, they had just landed on a continent that had no recognizable system of law. And that created this huge legal vacuum, a black hole they needed to fill, and they needed to fill it fast. And the key that unlocked their solution was this powerful two-word Latin phrase, terra nullius. It literally means land belonging to no one. Now, and this is super important, this didn't mean they thought nobody was living there. They could obviously see the indigenous people. What it meant was that in their view, the societies already there didn't have a legal system or a concept of land ownership that British law could recognize. So by declaring the land terra nullius, Britain could say it was settled, not conquered. And that little distinction, it had massive, massive legal consequences.
Okay, so with the continent legally stamped as settled, the path forward was pretty clear. Why invent a whole new set of rules when you have a perfectly good one back home? So that's what they did. They essentially imported the whole shebang. The entire body of English law was just loaded onto the ships and brought over. This whole process has a name, the doctrine of reception. The easiest way to think about it is like installing a brand new operating system on a computer. Because the land was settled, all English laws, every statute, every judicial decision were automatically received. They became the source code for this new society. And they even set a specific cutoff date, which basically took a snapshot of English law at that exact moment and transplanted it directly into New South Wales.
But you know, there was a tiny problem. An operating system built for one type of machine doesn't always run so smoothly on completely different hardware. The legal system of a small, green, ancient island nation was now being forced onto a vast, dry, and totally different continent. And the fit was, well, let's just say it was incredibly awkward. And this right here, this just shows you that mismatch perfectly. On one hand, you've got these complex English laws for inheriting a tiny little farm. On the other hand, you've got the Australian reality of a 10,000-acre land grant in the middle of nowhere. How on earth do you apply laws written for bustling London to a brand new penal colony where just staying alive is the #1 priority? It just didn't work. It created what legal experts call repugnancy, where the imported laws were just fundamentally unsuitable for life on the ground. This quote absolutely nails it. A law that makes perfect sense for the small fields and ancient villages of England becomes almost nonsensical when you try to stretch it across the vast, unfamiliar landscape of the Australian outback. Now, this awkward fit wasn't something people could just ignore. It kicked off this incredibly long process. We're talking nearly 200 years of legal adaptation. Australia had to start tailoring this ill-fitting suit it had been given, slowly but surely shaping a legal system that was actually its own. And this timeline really shows you that long road to independence. It wasn't a single event. The first real crack appeared way back in 1865, with an act that let the colonies start tweaking some English laws. Then came the big one, Federation in 1901, creating Australia's own constitution and its own high court. The pace really picks up in 1931 with the Statute of Westminster, which gave real legislative freedom. But, and this is amazing, the final cord wasn't cut until 1986. The Australia Act is what finally severed the last ties, making the High Court the top of the legal food chain. After almost 2 centuries, the journey was finally complete. But even after all that, after finally getting legal independence, that original import left a permanent mark. You can still see that English DNA running right through the heart of Australia's legal system today. So what does that English DNA look like? Well, it's the really big stuff. Our whole common law system, where judges' decisions help create the law, that's straight from England. The adversarial system in our courts, 2 sides arguing it out in front of a neutral judge, that's from them too. Our entire model of parliamentary democracy is based on the Westminster system. Even those core ideas we just take for granted, like being innocent until proven guilty, it's all part of that original blueprint.
So, at the end of the day, maybe the best way to look at it is this. The foundation was definitely imported. The legal blueprint was British, through and through. But the house itself, the actual structure that stands today, that was built over 2 centuries by Australians, using local materials and constantly adapting the design to fit a totally unique place. And that whole story, of a legal system taken from one place and slowly reshaped into something new, it leaves us with this one last, really fascinating question to chew on. If a legal system is imported, can it ever truly belong? It's a question that really gets to the heart of what law, identity, and history are all about.